Welcome to everyone. We are back from a short summer break, and as Thorsten mentioned, this is our sixth session. And before we start with today's topic, just a word on our website. You can already see the next events we have organized in October, November, and December. The registration is not yet open, but will open soon. And I also wanted to recall that since June, we have opened a blog, so we welcome submissions on any topic related to dispute resolution in space. So please feel free to write to me or Jan, who is in charge of the blog. And before we start, thank you again to Thorsten and to Spacewatch Global and to Chiara, although she's not here today. We are really grateful for the support. And for anyone in the audience who's not that familiar with the space industry, I've been reading Thorsten's newsletters for the last 2 years daily, and I think it gives a really great overview over what's happening in that industry. So with this, we can turn to today's topic, one I'm particularly excited about because I have a background in public international law and investment arbitration, and this is the perfect combination between space and those areas. So I'm very much looking forward to today's discussion, and I think we have a great panel. We will discuss mainly two aspects. We will talk about space mining, property rights, and protection of those activities. And we will also talk about the applicability of investment protections to satellite activities in space. So we have here with us Dr. Rosana De Plano, who will speak about space mining and investment protection of those activities. Simon Maynard, who will speak about property rights in space. Professor Hobe, who will discuss the applicability of international investment protections to satellites. And finally, we have Dr. Gershon Hasin, who will tell us about the risks of extending international investment protections to outer space, to give the other point of view as well. I will introduce each of them throughout the conference, and we will now turn to our first speaker, Dr. Rosana De Plano. Rossana is an associate professor and co-director of the Center for European Law and Internationalization at the University of Leicester in the United Kingdom. She specializes in public international law, including international space law. She also serves as the space law advisor for the Asteroid Mining Corporation, and holds a PhD from Brunel University in London and a PhD from the University of Nottingham. She is the author of the Artemis Accords, Evolution or Revolution in International Space Law. So with this, Rossana, we are looking forward to hearing from you. Thank you.
Thank you. Thank you very much, Laura and Thorsten as well. And happy birthday, by the way. Thank you for the kind introduction and also for giving me a pretty difficult topic for today, the idea of space mining and the role of arbitration in space mining disputes. I would like to start my presentation, bear in mind that it is a perspective activity, so we don't have any practice we can discuss today on this specifically. But I would like to start my presentation by somehow unpacking the concept of space mining. Why? Because we tend probably naturally to associate space mining with the actual extraction of resources from a celestial body, whether it is an asteroid or a planet or any other celestial body. But actually, space mining is a complex activity, or more specifically, it is a sequence of activities and not a unitary concept. And I think that this idea of complexity really can be divided into technical complexity, but also legal complexity, which stems from the technical complexity. So let me say a few words about technical complexity, also to give you an idea or a flavor of the stage of development of the technology, and then I will touch upon the idea of legal complexity. Now, technical complexity, as I said, in my view, refers really to this sequence of activities leading eventually to the mining of space resources. And it seems to me that all of the companies, private companies, which are planning to eventually mine space resources from celestial bodies, is following, roughly speaking, the same structure of mining we use for resources here on Earth. So we can expect that, generally speaking, space mining operations will have three components, will basically be developed into three stages: prospecting, exploration, and eventually exploitation. I will say a word about each of these phases. Prospecting essentially consists of the remote sensing of a celestial body by a satellite, whether it is an asteroid, a planet, or any other celestial body. And the current stage of development of space mining companies really suggests that we can expect in the next 2-3 years to see private operators starting the prospecting phases. So the technology is already there and it is developed mainly because they need a satellite for the remote sensing of the celestial body. The second stage, the second phase, is the exploration. Exploration means, in short, the extraction of a sample of minerals from the celestial body which has been targeted. And this will happen not in a random way, but after the prospecting phase has been satisfactory for the commercial entity, not least because the sample extraction is going to be a very intensive and expensive phase. So we should expect a very careful targeting of the celestial bodies for sample extraction. Now, in relation to this second stage, I'm pretty confident when I say that the technology is already fairly developed, not least because the extraction of samples of resources is going to be done also in relation to scientific explorations. For example, the Artemis missions, which are due to start probably tomorrow if it is successful, the launch, but very, very soon. So what I mean is that the private companies already have the know-how to do the extraction of samples of the resources from celestial bodies, and they are already proceeding at a quite fast pace in actually manufacturing their own robotic probes. So we could expect in around 5 years' time to see private companies engaging in the first extraction of samples from celestial bodies. And then the third phase is the proper exploitation, which means the extraction at a commercial stage, extraction of resources at a commercial stage. And again, we should not expect reckless actors just randomly extracting resources from whichever celestial body. Again, this is subject to the successful completion of the second stage, so the extraction of the sample and also the analysis of the sample, which confirms that there is a good prospect for commercial exploitation. And my understanding is that in relation to this third phase, so the full-scale exploitation of resources, this is, roughly speaking, a decade away from now, which means that the proper extraction of resources at commercial stage is not going to be around the corner as an activity, but at the same time, it's not in the distant future. We are getting closer and closer, and so we should bear that in mind as lawyers when we discuss the lawfulness of space mining, and specifically for today, the role of arbitration in space mining disputes. So these, in short and broad brushes, probably are the technical stages of commercial space mining. But as I said, associated with technical complexity, there is also legal complexity. What do I mean by legal complexity? Well, in my view, these three stages of technical complexity really raise a set of legal questions, even in perspective. And so there are probably several questions today in the limited time that I have. Probably I would like to discuss with you only 3 questions. And so what type of legal issues space mining involves? And therefore, if there are legal issues, what type of disputes space mining is likely to generate? And then what is the role of space arbitration in space mining disputes? So let me go back to my own first question for today. What type of legal issues space mining involves, or it is likely to involve? Here, I think it is useful, just for the sake of clarity of the exposition, to bear in mind the 3 sequences, the 3 phases in space mining. It is probably not difficult to predict that, for example, at the prospecting stage, the type of legal issues that may arise are related to the sharing of the data, which will be collected via satellite remote sensing, but also other issues, for example, related to space debris. If we complete the prospecting stage and then we leave our satellites simply orbiting around a celestial body, that is something which goes straight against every single recommendation against space debris, or if there is a collision that could generate space debris. So these type of legal issues are not difficult to imagine as happening at the prospecting stage. But then if we move forward in the next two stages of non-operational space mining, the sample extraction and probably even more so the proper full-scale extraction of resources, other legal issues which are in all likelihood going to arise, for example, related to property rights. And I know that there is another presentation today which delves deep into these questions, but also, for example, the idea of priority rights, which means who is going where, for how long, and to do what. It's all about transparency of declaring what you are going to do. But there is also the complex concept of safety zones, which in my view are nothing more and nothing less than areas subject to notification and consultation, but it is a contested concept, or why not, even benefit sharing. Benefit sharing is a legal obligation, not a moral obligation. It's a legal obligation which is written up front in Article 1 of the Outer Space Treaty. And the problem of benefit sharing, meaning sharing the benefits deriving from the utilization of space resources, it's something which is already discussed within Corpus and probably will emerge as one of the important legal issues. There are obviously legal issues that also can happen in each of these three stages. So I'm not trying to compartmentalize in a very dogmatic way the type of legal issues. If we think of space debris, as I said, it can easily happen at the prospecting stage, but probably even more so in the extraction of the sample and full extraction stage. If we think of what is going to happen from a pragmatic perspective, there are going to be plenty of rocks flying when a space mining operation is going to take place, and therefore that is a type of space debris which is generated with all the risks of damaging probably other sites in proximity of the one which is performing the extraction, and so on and so forth. So I didn't want to sound dogmatic. I was just using those categories for the sake of the exposition. So I think that there are plenty of legal issues which can arise, and this leads me to my second question. What type of disputes, therefore, space mining is likely to generate? And in relation to this question, I think it is useful from my own perspective to distinguish between two types of disputes. There are going to be disputes for sure which relate to the interpretation and application of the space treaties. This can be, for example, disputes on property rights over space resources, safety zones, priority rights, and so on and so forth. And then the second category of disputes, in my view, relates to the actual conduct of these operators, so the actual mining extraction activity. And these disputes probably will include things like space debris on or around the mined celestial body, damage caused or potentially caused to the equipment of another space mining operator in proximity, and so on and so forth. These are very pragmatic issues which could lead to obviously disputes, legal disputes. And so having this distinction in mind of two typologies of legal disputes related to space mining leads me to the question for today, which probably is the juicy one for the purposes of this talk. So what's the role of arbitration in space mining operation? Again, we are thinking in perspective because we don't have any state practice or practice from private actors that we can discuss properly. And I think that when we imagine a role for arbitration in space mining, there are both prospects and challenges ahead. And so advantages and disadvantages, in other words. In terms of prospects or advantages, I think that one is macroscopic. And so arbitration, if it were to take place even today, for sure will provide legal certainty. And that would be to the advantage, for example, for investments on space mining, to the advantages to the private operators when they do their own business plans and so on and so forth. And therefore, as a trickle-down effect, also advantages to states, but also other space actors, including, for example, international organizations interested in these activities. So there are many advantages, the most important of which is legal certainty. But precisely because of this, because of legal certainty, I also see that there are many challenges. It's like the other side of the coin now that I want to discuss very briefly. As I said, if arbitration were to take place today in relation to space mining, will provide legal certainty, but arbitration will also take place against a contested, to say the least, legal background. There is no unanimity in the key provisions of the Outer Space Treaties, not even when we look at the Outer Space Treaty of 1967, which is the constitution for outer space. So there is a contested legal background against which arbitration is going to take place. And so if arbitration were to go ahead, especially in relation to those disputes related to the interpretation and application of the treaties, I suspect that it will not, in a sense, received very well from a huge chunk of the international community of states. Why? Because this will amount to giving an arbitrator the power to interpret or to provide an authoritative interpretation of the space treaties. And if we look at the practice of states within corpus, including within the legal subcommittee, at the very least in the past 30, 40 years, time and again, consistently, several delegations have objected to this idea of depriving states of the power of interpreting the space treaties for their own interests and giving this power, even hypothetically, to a court of law or a panel of arbitrators, okay, to decide. This, for example, was the case when the Cape Town Protocol in relation to the space assets was discussed within the legal subcommittee, but there are plenty of examples in relation to the other issues on the agenda of the legal subcommittee. So to conclude on this point, and in a sense to wrap up in relation to my presentation, I think that probably arbitration is a no starting point for the progressive development of international space law when it comes to space mining. Probably a multilateral forum like COPUS and its legal subcommittee is a better starting point to clarify these gray areas of interpretation, especially of the space treaties. And indeed, we all know that earlier this year, in April, COPUS has actually created, has established a dedicated working group on the lawfulness of space resource activities, including space mining. So probably this work, which in 5 years' time or so will lead to the production of the text of the new resolution to be adopted by the UN General Assembly, will facilitate this process of coming closer to a more agreed upon interpretation of the treaties. So to conclude, in my view, the first category of what I see as the first category of space disputes, those related to interpretation and application of the space treaties, at the moment, it seems to me they are not well suited for arbitration or even adjudication, because it will take place against a legal background of contested interpretations of the space treaties. And that is very difficult to circumvent at the moment. Whereas the second category of disputes, those which relate to the actual conduct on the ground of potential operators for space mining, that is more suitable for arbitration, and also, in all fairness and honesty, probably also suitable for adjudication and the other means for peaceful settlement of disputes, which are indirectly referred to, for example, in Article 3 of the Outer Space Treaty, but also it could include something like the Claims Commission for Liability Cases, which is established by the Liability Convention of 1975. I guess I'm going to stop here for the presentation, but I will be very happy to take any questions that the audience may have. So thank you very much.
Yes, thank you very much, Rossana. It was very interesting. I have a question. You mentioned that there are factors that speak against arbitration, but I mean, maybe by the time space mining will become a reality, those questions will have been resolved, so those legal questions. But do you think there are any factors that are in favor of arbitration for space mining, and especially maybe for private companies and not so much for states? Could you say a few words about this?
Yes, you're basically asking me whether private actors will have recourse more often, or there are the prospect that space actors will have recourse to arbitration more often than public actors. This is a difficult question, and again, I'm probably predicting my answer and state practice. I honestly and genuinely don't think that the private or commercial actor versus public actors is a very useful line of distinction when it comes to arbitration. So I don't think, in short, that private or commercial actors will necessarily have recourse to arbitration more often than public actors. This simple consideration to me suggests that arbitration is actually not going to play any qualitatively, not quantitatively, qualitatively different role, for example, in relation to commercial space mining as opposed to space mining, which is going to support scientific operations. It may be that there will be more commercial operations in outer space than scientific operations, and therefore there will be more recourse to arbitration from the side of private commercial operators as opposed to those doing scientific research. But that is more a quantitative rather than qualitatively difference. And also here, I would like to take this opportunity to note that probably it's even difficult from a theoretical and practical perspective to distinguish between activities which are purely commercial and probably will invite arbitration, and activities which are done in support of scientific research, which don't create any legal problems from the perspective of the space treaties. Imagine a company which is extracting resources for the purposes of then making them available for support of a scientific mission. Could be, I don't know, an Artemis mission, for example, or something like that. And suppose that a company does that within the framework of the scientific mission. So with a subcontractor, as a subcontractor, it is extracting resources to make them available. The same thing could be done completely outside the framework of a scientific activity, and so the operator could simply be extracting the resources, which then will be made available to scientific operations. So you see that it is very difficult to clarify an action as such as purely commercial or in support of scientific activities. And so probably to go back to your question, my suggestion would be, and probably an invitation to the legal community as such, including the space law advisor to these private companies, to select very carefully or to invite arbitration very carefully in relation to those type of disputes that I have discussed a few minutes ago, which lend themselves to be decided by arbitration. So in other words, to avoid arbitration, to try to provide an authoritative interpretation to those key gray areas and key provisions of the space treaties, which as of today are still under discussion within COPUOS, and also there is no agreement, not even among scholars. So there is no benchmark for assessment. This idea of being very careful in selecting today, even before space mining starts, which type of activities and legal issues are suitable for space arbitration, that is the key for facilitating entering in this idea that space arbitration has a role in space mining activities. And this is irrespective of the fact that it is a private or a public actor which is resorting to arbitration, and irrespective of the fact that it is a purely commercial or a space mining activity in support of a scientific exploration that we are talking about. So all in all, that would be my invitation, to select very carefully the type of legal disputes that we want to bring to arbitration, to avoid disappointment or those rejection on part of states if they feel like they are deprived for all practical purposes of their power to interpret the space treaties. I hope that answers somehow your question.
Yes, thank you very much. I have one very short and more practical question to end your presentation. based on your personal experience advising a space mining company, do you think space mining companies are aware of arbitration and take this into account? Or do you think there needs to be more work done to create more awareness of arbitration?
No, I think they are well aware of arbitration. Actually, it seems to me it's become a sort of buzzword. Everything can go to arbitration. According to them, it's just not an easy way, but a handy way of having a decision which is binding on the parties to sort out whatever sorts of problems they may encounter. I think that they are actually too optimistic in terms of seeing arbitration as a one-size-fits-all solution. The space treaties and the history of space law is still today heavily based on a lot of diplomacy. That's why the space treaty have many provisions which invite consultation, dialogue, and also if we consider that space law as such is inspired by the principle of actually dispute prevention rather than dispute settlement, I think we should be cautious in advising these companies, but also probably make them aware that arbitration is a very useful tool. It's going to be very, very effective, but I don't think it's the one-size-fits-all solution. There are certain legal disputes, especially those which touch upon the very, very sensitive issues for states. They, at the moment, those types of disputes are not very suitable for arbitration. So actually, I would caution at the very least having this embedded assumption that whatever happens, there will be arbitration and all problems will be sorted. There is still probably a fine layer, if you want, of diplomacy or dialogue even among private actors, and I would very much encourage to take into consideration at the same time arbitration and be aware of arbitration. We have a beautiful set of arbitration rules for space disputes, and so it's also time to put them into use, but also taking into considerations that there are these other sensitivities, and we are talking about a field of law which in itself is still in the development phase when it comes to space mining and use of resources, and also that there is no practice on part of the private actors. So acting with a bit of caution, I think, and also, as you say, with a lot of awareness about the tools available, that's the best way to proceed, in my own view. I would advise this way, honestly.
Thank you very much, Rossana. We will now turn to Simon, who will speak to us about property rights in space. So Simon is a senior associate at King & Spalding in London, and he resolves complex commercial disputes under English and international law, and has particular expertise in international commercial and investment treaty arbitration with a focus on disputes concerning the extractive industries and also the energy transition. Simon is recommended for international arbitration in Legal 500 and is shortlisted for UK Lawyer of the Year at the 2022 Legal Business Awards. He is also a leading advocate for disability inclusion in the legal profession and is co-chair of the International Chamber of Commerce Task Force on Disability Inclusion and International Arbitration. Thank you very much, Simon, for joining us today. And the floor is yours. Thank you.
Thank you, Laura. I want to start by answering a question which has a simple but important answer, which is, why does the protection of property rights in space matter? And the answer to that, I think, is two things. One, value, and two, the protection of that value. What we know is that space has the potential to be a significant source of natural resources. To take one example, there are rare earth metals, which, as Professor De Plano has told us, can be mined from space, and those kinds of metals are vital, for example, to many technology products, as well as to energy transition technologies. And there's an important geopolitical component to that, because 90% of those types of resources are currently produced in China. So for other global superpowers, there's a very significant incentive to find an alternative place to source those kind of metals from. So that's value. And then the question is, how do you protect that value? And again, Professor De Plano talked us through the 3 stages of resource mining: prospecting, exploration, extraction, and mentioned that the first 2 of those involve very...
We can't hear you anymore, Simon. think there.
You should be able to hear me again. Apologies. I had
Yes.
an incoming call from someone who can't see the little red button saying I'm busy. That mentioned that the first two of those involve very significant expense. And the question is, why would you incur that expense if there is no way to guarantee that you can protect the value that you obtain at the end of it? And that is, of course, where property rights come in. If you don't have property rights, it's very difficult to stop abuse of the value that you extract. It's difficult to assert legal rights over that value. And if you can't do those things, it is difficult, I suspect, to justify spending the money in the first place to extract and indeed enhance the value therefrom. So that brings me to the second question, which is, what is the kind of basic international legal architecture that we need to start off as the jumping off point? And again, we've heard that the Outer Space Treaty is effectively the constitution for this kind of process, if I can call it that. And that's obviously key. That has been signed and ratified by 110 countries, including, importantly, the most important spacefaring nations. So the US, Russia, China, the European Space Agency, and a whole raft of other countries. And then it has been signed by a further 23. So that has, if you like, critical mass behind it. Now, Article 1 of the Outer Space Treaty provides that outer space shall be free for exploration and use by all states, provided that such exploration and use shall be the quote-unquote provenance of all mankind. And then Article 2 subjects that to a further proviso, which is that outer space is not subject to national appropriation by claims of sovereignty by means of use or occupation or by any other means. That then gets us to this very tricky question of what we mean by the common heritage of all mankind. It's fair to say that it's a slippery and indeed contentious concept. Now, one definition that I think is a helpful one by and large from the Handbook of Space Law says that the idea involves that certain areas lying outside of national jurisdiction for reasons of scientific and commercial value shall be commonly managed by all states on behalf of mankind and cannot be appropriated, and this is perhaps where things get particularly contentious, by a single state or private person. So arguably, the Outer Space Treaty itself precludes private property rights in space, but it's fair to say there's at least some wiggle room for non-state actors. Now, let me contrast that with the other major treaty, which is the 1979 Moon Agreement, and it's important to note that that has only been ratified by 18 countries and signed by 4, and the US is not one of them. And there are good reasons for that, which is that the Moon Agreement is essentially more restrictive and less equivocal about property rights. So it doesn't have that same kind of wiggle room for non-state actors. And that is why it's been, I think, among the reasons it's been explicitly rejected effectively by the United States. Now, building on that international legal architecture, there have been a number of subsequent developments, both international and domestic, that have begun to explore the possibility of allowing the legalization of the appropriation of natural resources in space. And it's those I want to turn to now. The first of those, again, we've had a reference to already, and that's the Artemis Accords, which, as it were, govern, or a sense of principles that govern the civil exploration and use of outer space, and they underpin the Artemis program. And that's we're hopefully going to see the first flourishings, as it were, of the Artemis program tomorrow. But among the things that the Artemis program is looking to do is land the first woman on the moon and the next man on the moon by 2024. The Artemis Accords put some flesh on the bones of the Outer Space Treaty. And I think another element of them that's important is that if you want to be part of the Artemis program, you have to comply with the Accords. So in that way, they have a kind of soft enforcement mechanism built into them. The Accords provide for the extraction of resources in accordance with the Outer Space Treaty, recognizing that such extraction will be critical to support safe and sustainable space exploration and development. But of course, as I say, they provide for it to be done consistently with the OST. So on the one hand, they specifically envisage extraction of resources, but arguably because of the reference back to the OST, they then kind of don't move the dial. The next development internationally that I should mention are the building blocks for the development of an international framework on space resource activities. These were only adopted very recently in 2019 by the Hague International Space Resources Governance Working Group, which is a group of major stakeholders. And the building blocks provide that they look to ensure that rights over extracted space resources, as well as products derived therefrom, can lawfully be acquired through domestic legislation, bilateral agreements, or multilateral agreements. And in 2020, the US gave approval for the negotiation of such bilateral agreements. So again, we see, based on those building blocks, we see, without wishing to mix my metaphors, further baby steps towards the legalization of a system of privatized property rights. And according to the commentary to the building blocks, the key legal basis for Section 8.1 is the freedom for all states to use, you'll remember back in Article 1 of the Outer Space Treaty, the ability to use space in that way. And a couple of, some states have already sought to, well, in fact, prior to the building blocks, have already sought to take advantage of that ability to effectively allow for the possibility of private resource exploitation in their national legislation. One of those, perhaps not surprisingly, is the US. The US actually published the Space Resource Exploration and Utilization Act in 2015, but that was followed far more recently by Executive Order 13914 in April of 2020, and that actually explicitly asserts the right of Americans to engage in commercial exploration, recovery, and use of resources in outer space. And so you can see there a fairly, I would suggest, a fairly explicit rejection of the, as I say, by the US unsigned Moon Agreement. The other country that's done this is, or one other country that's done this is Luxembourg, which passed the law on the exploration and use of space resources in 2017. And again, that also takes as its opening premise that space resources are capable of being appropriated. And the Deputy Prime Minister, or then Deputy Prime Minister of Luxembourg, was actually kind of on the record as suggesting that the Luxembourg Space Mining Act is in line with the Outer Space Treaty. And the suggestion is that it respects the basic principle of non-appropriation because it allows for the appropriation of resources by private parties and does not make any territorial claims or attempts to establish sovereignty in space. Now, query how many angels that is dancing on the head of a pin, but it's certainly a fine line. So where do we end up? Well, the old cliche is that private rights in space have traditionally been a legal black hole. I think what we can say is that bit by bit, we appear to be emerging from the darkness. Thank you very much.
Thank you, Simon. I have a question that is asking for a subjective answer, but based on your experience in working with mining companies, how do you think those companies would approach this legal uncertainty? Rossana cautioned that arbitration might not be the best way of resolving this because the interpretation of the treaties need more authoritative opinions maybe than international arbitration tribunals could give. But how do you think companies would approach this? Would they be willing to take the risk, or would this be a factor that would really prevent space mining for the moment if this cannot be resolved?
That is a great but certainly difficult question. I think it's like a pair of scales, and there's legal certainty here and there's economic reward in this one, and I think it depends how hard you're pressing on either. And somewhere there will be a balance where there's an acceptable level of legal risk with an acceptable level of economic reward, and if the economic reward is high enough, then that's going to perhaps press hard enough down on the scales to make the risk acceptable. And I, you know, that's, I think, the equation is what is the balance of risk and reward. The greater the legal uncertainty, then the greater the potential upside will have to be. And not only the greater the potential upside, but of course, it's not just about how big the upside is, but how quickly you can realize that upside as well. So, and this, I'm afraid, is where I begin to, for example, run into a lack of non-legal expertise. But if you compare it to, for example, mining in the earth, or indeed, for example, looking for some kind of other extractive process like, you know, oil and gas extraction, that is obviously a highly scientific process, and yet still one that can take years and years and years to realize any kind of commercial discovery. And in fact, it's not uncommon to go through an entire, for example, exploration, what's called an exploration period, without even finding anything that's of commercial value, and then you simply hand the land back to the state. What I can't speak to, because it requires geological expertise, is how that maps into space and how readily available the resources are, how much kind of upfront investment and how much uncertainty there will be about even finding the resources in the first place. But I think that would likely be a relevant consideration.
Yeah, maybe we can come back to this topic at the end if we have time. But I think also in the geopolitical context, maybe there will be public backing also to make it possible, just to, in terms of the rivalry between China and the United States. I could imagine.
Yeah, that's a great point, actually. That's a great point that I didn't weigh in my scales. That you're quite right. For some actors, there will be a third consideration, which may trump that may also lead to trumping the risks that we've mentioned.
Right, thank you very much. We will now leave space mining behind for now and turn to satellite applications in space. And we will look at whether those can be protected by the international investment protection regime. And we will first hear from Professor Hobe. Professor Hobe is the director of the Institute of Air Law and Space Law and Cyber Law and managing director of the International Investment Law Center in Cologne and at the University of Cologne. He's the legal advisor of the German government at the United Nations Space Law Committee, and he also acted as exit arbitrator between 2014 and 2018. So it seems he is very well placed to be an arbitrator in the next investment cases arising in the space industry. So we are lucky to have him here today. And Professor Hobe, we are ready for your presentation. Thank you.
Thanks very much, Laurie. Thank you very much for your very kind introduction. I totally disagree with what has been said so far. But this is, of course, necessary for any dispute. I disagree on what is going on with space mining, which I think is legal, but well, it comes to the, pointing these things to the earth, it becomes illegal. My point today is to talk about the applicability of international investment protection and the protection to satellite communications, which is a very difficult topic to which very few people have written. So the question of the applicability of the international investment protection to satellite communications has rarely been discussed. However, that this is a very important sector reveals from the fact that the telecommunications industry is in very good shape. In 2020, it generated global revenues were at more than 350 billion US dollars. With this, the satellite industry is good for more than half of the revenues in the space sector. For those of you who are more familiar with arbitration and with investment arbitration, I tell you briefly, space law consists of 5 international agreements. The Outer Space Treaty of 1967, which gives you a broad roundabout of all human activities in outer space. Rescue Agreement of 1968, the Liability Convention of 1972, the Registration Convention of 1975, and the Moon Agreement of 1979. So what is important for me to say is it can be observed that different phases of satellite activities all start with the so-called pre-launch phase. I want to distinguish launching activities in different phases in order to, well, earmark the most important legal issues. The first relevant phase is the so-called launching phase. That lasts from the ignition of the launch vehicle to the on-orbit release of the satellite. This phase is the most precocious form of all. During launch, unpredictable events can happen and may result in severe damages to or even the loss of the satellite. The second phase, the so-called on-orbit phase, starts with the satellite is separated from the launch vehicle and reaches its final orbital position. For example, telecommunication satellites are often placed in geostationary satellite orbit. But then, as the last phase, we have the end of lifetime phase, where the satellite ceases to provide useful services and becomes a non-functional object. If we asked for coverage for investment protection, the first question is on whether telecommunication activities can qualify to be an investment. Typically, bilateral investment treaties contain a very broad definition of what constitutes a protected investment. It can be every kind of asset. This can inter alia be shares, bonds, loans, contracts, and intellectual property rights, or licenses, permits, tangible or intangible, and movable or immovable property. Consequently, the satellite itself and contracts regarding its launch and operation will be considered as a protected investment under most bilateral investment treaties. Moreover, such would also count as investment according to Article 25 of the ICSID Convention. Moreover, an investment must consist of a contribution with economic value. It can thereby take any form and is not limited to financial contributions. This can also include know-how, equipment, personnel, and services. Finally, several tribunals have considered that an investment should also contribute to the economic development of the host state. Since the development impact of transactions is extremely difficult to evaluate, it has been argued that this requirement is implicitly existent in the other three characteristics that are present. Moreover, it is to be clarified which state can be seen as the host state. Finding an answer to this question is complicated through the multilateral nature of telecommunication activities. In view of these specific circumstances, it seems to be impossible to identify only one single host state for the entire satellite project. It rather seems appropriate to determine the host state in relation to each phase of a satellite communication project. As a consequence, an investor may be able to bring investment claims against several host states in the course of 1 satellite project. Which of the host states is responsible under the international investment law obviously depends on the attribution of the state conduct in dispute. Finally, we will focus on the typical risks that private investors encounter in the different phases of a satellite cooperation. From the very beginning, a satellite operation takes place within a legal environment which the success of the private investment depends on a large extent on long-term commitments made by state entities through contracts and administrative licenses. Consequently, umbrella clauses are highly relevant to investors since this makes compliance with such legally binding host state commitments into an obligation under applicable BITs. The cases where the applicable BIT does not contain an umbrella clause, host state commitments might still be protected as legitimate expectation under the Fair and Equitable Treatment FIT standard. In view of the imminent physical dangers a satellite is confronted with during the launch, the principle of full protection and security (FPS), which is typically contained in investment treaties, is also of particular relevance to telecommunication satellites. Its specific purpose is to put an obligation on the host state to provide, in order to provide a certain level of protection to foreign investment from physical violence, unquote. The on-orbit phases are particularly relevant for investments in telecommunication activities, since the economic viability of the whole venture largely depends on the trouble-free operation and maintenance of the satellite for approximately 10 to 15 years. In comparison to the launching phase, the immediate imminent physical changes of a satellite operation are even more evident during the on-orbit phase. Physical dangers include the collision with space debris on other satellites. Under extreme circumstances, a private satellite could also face destruction by anti-satellite missions, so-called ASAT weapons, launched by a third state for strategic purposes. In addition to the satellite itself, the right to use specific frequencies and orbital position is vital for the space venture's economic success. In the context of international investment law, a distinction can be made between the physical protection of a satellite as a space object and the rights obtained by the investor for its operation, namely the frequency rights and orbital size. At the end of their operational life, satellites are typically moved into orbits away from common operation orbits. Here, also additional coverage against the risk of damage must be taken. Thank you very much, Laura Yvonne. Thank you very much for giving me attention for these 10 minutes. Thank you.
Thank you. I have one question, because usually the investment protection treaties contain the condition that an investment must be made in the territory of a host state to benefit from the investment protections. But by nature, obviously, space investments are not within the territory of a host state, but in outer space. So how would you look at this problem in terms of applying the investment regime to outer space investments? Do you think it's possible, or would that be an obstacle?
I see that you're a specialist in investment law. I see it immediately, and I think you are right. Who is thus responsible, the host state, and why? Well, this is, of course, a dependency on the phase that, of course, I would say that states who, well, that Article 8 of the Outer Space Treaty gives us the answer. Article 8 of the Outer Space Treaty gives the idea of, well, you know, that the state that has the respectable dependency, the respectable, let's say, the responsible
Link.
links, exactly. That is the link of a state towards the respective object in outer space. And that is the state of registry according to Article 8 of the Outer Space Treaty. That gives us the responsible state for these things, which is sometimes difficult to demarcate, but well, that is what outer space law gives us as a so to speak task to do. Thanks very much.
Thank you very much. So now we will hear from Gershon, and he does not agree that it's a good idea to apply the investment protection regime to outer space investments, and I think it's important to hear both points of view. So Gershon is a visiting lecturer in law at the Yale Law School, where he teaches seminars on the law of the sea and on space governance. His research and publications focus primarily on the regulation of common resources under international law, and he has published in leading international law journals such as the Yale Journal of International Law Studies, and the Georgetown Journal of International Law. In addition to scholarship and teaching, he has extensive experience in international litigation and arbitration, including before the International Court of Justice. So Gershon, thank you very much for joining us, and the floor is yours. Thank you.
Thank you, Laura. I'm not sure that I completely disagree with the idea of extending investment protection or commercial arbitration to space activities, but more that we have to be careful when we do that. And we have to do that in a contextual rather than a textual way. Well, so you can't properly wrap up a topic without talking about the risks and challenges of any proposed policy, and I guess that's what I'm here for. Because it's my belief that risks absent the context are unhelpful, I'll give a brief introduction on what policy-oriented jurisprudence is, what's known as the New Haven School of International Law. But first, I have a brief example for context. With the development of private space activities, state participants which lack capabilities are incentivized to participate by attracting foreign investors. Now, the primary way for states to attract investors in these circumstances are through domestic laws and regulations. Such rules may increase the gains of investors and wealth through, at best, increased property rights, and at worst, reduced environmental and sustainability commitment. Now, the example I dealt with in a previous article was prescribing lenient obligations to mitigate space debris or otherwise relax their enforcement. But other problems may include worker protection, intellectual property, or emissions. Now, in the environmental context, jurisdictions attracting investors in such ways are referred to as pollution havens. Now, while a state may prefer immediate gains in wealth on account of future sustainability, the negative externalities produced, in my example, debris, affect all participants and primarily the developed space-capable states. Now, with perhaps the exception of launch facilities, activities in space, and I'm talking about the space-to-space industry, may be controlled from every country. And in the modern world, creating a domestic subsidiary is not such a difficult task. This indicates that this process risks turning circular, with states incentivized to reduce regulatory burdens on investors to encourage the relocation. Again, in the environmental context, this has been referred to as a regulatory race to the bottom, where every regulation is incentivized to reduce regulatory burdens to attract investors. Now, this process is difficult to arrest, absent norms increasing the costs of relocation or prescribing for regulatory minimums. Now, both are difficult, but the latter is especially elusive where it comes to international law, which we know is based on state consent, and in space in particularly where the applicable norms are limited and most investments are not tied to the host state's territory in the same way. Where it comes to arbitration, the most common example to consider is that of a foreign investor engaged in space activities, establishing operations in a state without space capabilities, to then be subjected to more stringent regulations, which significantly reduce the investor's gains in wealth while promoting the common interest. Now, assuming that the home state of the investor is a developed space-capable state, several important questions arise which relate to what could be the rationales of investment protection. So recognizing that investment protection reduces risks for investors and thus the cost of relocation, does it still make sense for home states to encourage foreign investments in the state sector in the same way that it does for terrestrial investments? And of course, should a tribunal protect an investment which took advantage of a supposed pollution haven? Can, or in fact, should it act otherwise? Now, in policy-oriented jurisprudence, we treat international law as a set of arrangements intended to shape the policy choices of participants towards the common interest. We focus on the process of interactions between the participants, considering their correlating and conflicting goals, interests, and points of leverage to understand what the probable outcomes of the interactions would be and how to shape decisions towards the preferred outcomes, which promote the common interest. The common interest being both the preservation of the minimum order, which refers to the prevention of conflicts, and promoting the optimum order, which is defined as the aggregated gain in international values for as many participants as possible. Now, where it comes to considering the lawfulness of a decision or the process of international law's evolution, we distinguish between two modes of decision. The first is called the textual rule-based mode of decision, in which the question asked is what rule applies. The rule is then interpreted and applied, producing claims of illegality, suggested policies, or proposed arrangements. Now, this mode finds its origins in interactions we have in domestic law, where there is a high, or in some circumstances, even a certain probability that the lawfulness of a decision be subject to a legal decision maker. For example, be it a court, a tribunal, or even an administrative legal decision maker, such as the Attorney General. Now, this leads us to treat the rule itself as authoritative and as one controlling decisions. We may even assume that the rule is enduring and must lay at the foundation of any other proposed rules. Yet in international law, that's quite a precarious way of thinking about law, because rarely a court or tribunal is in sight. International investment law, however, is one of those legal enclaves where the proposition of a legal decision maker is likely. For the majority of international legal arrangements, however, no tribunal or court may ever decide on legality. This is even truer when it comes to space governance, where many norms are outdated, vague, and may be easily denounced, lacking any meaningful enforcement except reciprocity. I think that Professor Hobe is sharing his screen for everyone. I'm not sure that that was intentional. I'm happy to continue anyway. So in these kind of offshore zones of international law, what we call the contextual policy-based mode of decision should be applied. Now, this mode of decision focuses on the participants involved, their interests, goals, leverages, bases of power, interactions, and outcomes. The focus here is on the goal values of the international community, which arrangements may effectively produce and distribute these values, and how these arrangements may be installed. While rules and norms need to be considered, those are considered not grammatically, but rather in their ability to shape decisions towards a desired outcome. In this mode of decision, where a rule is purportedly breached, it's far more important to consider how other participants perceive the act's effects on the international legal process rather than that the rule was breached. This may indicate whether the norm in question will be enforced, disregarded, modified through interpretation, or just abandoned as obsolete. Now, this mode of decision, which is the central tenet of policy-oriented jurisprudence, is focused on the process of interactions rather than the application of rules. Now, what's interesting in our subject of interest is the interrelation between two fields of international law where different modes of decision are appropriate. Now, if reverting to our example, one may ask whether a tribunal could interpret the terms of an investment treaty to apply to an investment dispute concerning space activities. A policy-oriented analysis would consider whether it should apply to the dispute, or if to be more clear, whether the underlying rationales of investment protection justify extending it to space investments, whether that will promote the common interest, and whether that is a probable outcome of interactions. My argument is that in most cases, it's not. Now, the first thing to distinguish is between the promotion of space investment and the promotion of foreign space investment. The second thing to distinguish in between promoting space investments and promoting sustainable space investment. Now, given the characteristics of space investments, I believe there's a big question mark on whether promoting foreign investment in space is consistent with the interests of home states of investors, or likely to be the developed space-capable states. Now, take a look at the United States as an example. Now, the US wants to develop a private space industry, not export that industry. As a major user of space for both commercial and military uses, the United States is interested in a sustainable space environment. For the US, which has launch facilities and plenty of office spaces, it makes little sense to encourage its space investors to relocate. Capital exporting states did not provide investment protection out of the goodness of their heart, right? They had interests involved, which extended beyond the mere protection of their nationals, such as access to natural resources, labor, promoting the rule of law, and more. So most of these aren't really relevant for space activities. Yet by allowing investors to switch their operations to pollution havens, or in the example I dealt with, debris havens, the United States' goals would be subverted. Not to mention the fact that space technology is dual use in many aspects. So while it's true that for capital importing states, or in this case, we're talking about technology importing states, they have strong incentives to encourage and promote foreign investment in outer space. But that's hardly the case for home states. On the contrary, right, these participants have more to lose than to gain from promoting foreign investment in space, not to mention providing investors with protection. In fact, some home states would gain if the host state, a previous debris haven, increases the obligations it imposes on space investors. So why should it provide any bid protections? So in approaching the question of investment protection for space activities, a simply textual-based mode of decision provides limited insight into the application and development of international norms. Yes, from a textual perspective, we may interpret treaties to apply, but from a contextual perspective, should the treaties apply? In my view, they should not, as they may reinforce a regulatory race to the bottom. Now, will the treaties apply? Now, that's a more difficult question, but given that the treaties counteract the interests of the major powers, it's less likely that the regime will remain fixed or interpreted in a certain way. Now, to conclude my presentation, it's important for me to say that, whether we're concerned with commercial or investment arbitration, because the decisions of tribunals may affect the development of norms, it's important for us to ensure that tribunals take public interests into account when making decisions rather than solely private interests. So the norms that we have at the end do not solely optimize private interests. Thank you for listening, and I'm happy to take any questions.
Thank you, Gershon. I think it's a very interesting and very important analysis. I have a question because, and I'm a bit biased because I wrote a short blog article on this topic. But don't you think that, for example, applying the investment regime to outer space investments, including, for example, the full protection and security obligation, could not also increase potential liability for host states for investment by allowing investments without the necessary protections? Because I think now also we already are, I think, in the situation where there's very little liability for allowing, for example, the creation of space debris. And the question is whether the investment regime could also be used to increase the potential liability so that maybe states have to think twice before authorizing or licensing these kind of activities.
Well, I'm trying to kind of think through your question, right? So when states authorize these activities, and especially full protection and security, I'm a little bit uncertain of how that affects the decisions of other actors in this case, or increases the chances of liability. I mean, if we think about it, investment protection is intended to protect the rights of the investor, not necessarily that of other actors involved in the process. So I'm sorry, I probably didn't.
No, I know. But for example, let's say Russia would be a host state to several investments. If it were to conduct an ASAT test, it would potentially put at risk its own, I mean, the foreign investor who have a host state link with Russia. Mm-hmm. So maybe it could work as maybe an obstacle to conducting these kind of activities. It's just a thought. Mm-hmm.
Yeah. So it's a really interesting thought exercise, right? I mean, I think that if we are to think about that, Russia won't be the prime example here, because I'm not sure that investment protection is really controlling Russian decisions. But so, extending arbitration as an instrument to resolve disputes in space can be a very helpful way of doing that. The question is twofold. First of all, whether or not it is in the interest of what would be the kind of the major actors in space to extend these protections to their investors, promoting certain relocation. That will be question one. The second question is whether or not we're able to promote norms through arbitration in a way which promotes the common interest rather than optimizing private interest. Whether in theory that could end up preventing some sort of tests of anti-satellite weapons, or limiting the authorization of other activities, which I think is a more on point question. I mean, that's I think a question for the future. The problem is that in a basic way, if investment protection counteracts its rationales, there's a lot to question of whether it should apply. And if we are thinking of how it should apply, we should think about structuring it in a way that is going to take account of public interests and not only the optimization of private interests. I hope that kind of answered your question. If not, I'm happy to clarify more.
No, of course it did. Thank you very much. I think Professor Hobe wanted to ask a question as well, and there's also a question for him in the Q&A about how an expropriation in space could actually look like, or how I think treaty violations in space would look like and could be resolved through the international investment regime. So I'll give the floor to Professor Hobe. You are on mute. Professor Hobe, you are on mute.
No, I'm mute. Thanks very much, Laura, for these very important points. I am very much of the opinion that any kind of, taking property in outer space repercussions on how this will take place on the Earth. These are fundamentally different regimes. It may be that something can be property in outer space, but it will certainly not be recognized on Earth, sorry. So there is a fundamental distinction between what we consider property in outer space and property on Earth. And therefore, it must be very clearly distinguished. Yes, it is possible that a country may acquire property in outer space, but no, it may not be possible for this country to acquire property on Earth. As regards, well, the specific conventions on investment protection, I think I have been showing the possibilities that are rather limited, but that are absolutely necessary, and therefore I think nothing else has to be said to that. Thank you very much indeed.
Thank you. There's another question. It's addressed to Rossana, but I think also Gershon might want to say something about this. It is about whether investment arbitration is the right forum to shape policies in outer space, and whether leaving this to investment tribunals would be kind of the concession that states were not able to do this appropriately. So maybe Rossana first, and I don't know if Simon or Gershon also want to add something to this.
Yeah, thank you very much for the question. I completely agree that beyond any law, including space law and arbitration, there is always an element of power that is in the nature of international law. Whether arbitration is the right place for developing policies related to outer space, I would probably point out that international law develops in two ways. On the one hand, there are treaties, customs, and general principles of law, the classic sources that we all know. And on the other hand, there is practice. And in many respects, these two elements go hand in hand. Whenever it comes to interpreting hard law, and especially treaties, then state practice comes in, kicks in, it becomes really, really important. The thing with arbitration is that, in my view, yes, obviously, the parties can present their own views and their own legal interpretation, even of the gray areas and the problematic provisions of the space treaties. And this is what is going to happen in arbitration if it were to take place. So obviously, if we are talking about powerful actors going for arbitration, they will present their own interpretation of the outer space treaty with all that background of interests protected by those interpretations. But the role and function of the arbitrators, in a sense, is slightly different. Arbitrators will need to decide by applying the law, whichever law is indicated by the parties. So if there is a simple indication or law to the outer space treaty or the outer space treaties, they will need to interpret those contested provisions, and not necessarily based on what are the interests that the parties are bringing in their own interpretation. So it becomes like a circular relationship. Arbitrators will apply the law, but if there is a contested interpretation, they will be forced to provide an interpretation. And this must be put in context of the dispute. So if we are talking about actions coming always from the powerful actors, because they have the financial means, the economic means, the technological means, and so on and so forth, in all likelihood, the policy or the development of the law, which will develop slowly or fast, I don't know, over time, will be probably more sensitive to those interests which pertain to only a certain part of the international community in this regard, or probably other interests. I'm thinking first and foremost on top of my head, the idea of benefit sharing, which probably is the difficult bit, which is a concern of a very large part of the international community, and it is unlikely to feed through the development of the law through arbitration. So there is a lot of law and policy going on. I think that not necessarily arbitrators will decide in order to support or not support one of the positions of the parties in terms of interpretation given to the treaties, but there is the risk that certain concerns of the international community will not fit into the arbitration process. And I have also read the question in the chat. There was the final question: what's the role of the scholars in this? It is to observe in a systematic way the normative development of the law via these channels, the sources of international law, and also state practice, and put everything into context and try to predict, trying to see argument and counter argument, what would be the implications of supporting certain interpretations or not, or the risk associated to supporting certain state practice or not. Having said that, as a scholar, I don't claim any completeness. I think that the discussion is rich and it will continue to be this way. So I think that also we need to take with a pinch of salt the power of us as scholars in directing the discussion. Thank you very much, Laura.
Gershon, Simon, do you want to add something?
Sure, I'm happy to. So I think, well, I think I spoke about the last question she spoke about, but for the first question, I think that we have to distinguish between investment and commercial arbitration. When we think about using arbitration to develop norms, investment arbitration is public, commercial arbitration is not. So my biggest concern when we look at institutions such as the Dubai Space Court, for example, is that, first of all, there's no transparency, but there will be repeated actors. And so if those institutions promote certain norms, those norms will be promoted between or shaping the decisions of the repeating actors, while they're not public and nor undergo public scrutiny in the same way as under investment protection. The other thing is that, and I think that Rossana stated something about this, is that arbitrators, both in investment arbitration and commercial arbitration, are supposed to apply a textual mode of decision. They are not supposed to take systemic considerations into regard. And by going through this instrument, we risk that the norms to be produced are going to be norms which are optimizing the interests of the actors involved in those disputes. And I'm not only talking about the whole notion of tribunals tending to refer to one another as kind of this process of not really precedent, but creation of different schools of thought. But it's risky to do this through arbitration because, as I said, we're risking the optimization of private interests or private actors and even state actors in investment arbitration have a tendency to present their own position, fighting for their own rights and proposing interpretations which promote their objectives. And in fields of law which are extremely underdeveloped, such as the governance of outer space, we risk creating norms which are going to give a significant preference to those private interests. So if we are to go that path, it's important to modify our view of arbitration and ensure that the decision makers, whoever they are, whoever the arbitrators are, they are allowed and encouraged to take account of public interest in the decision-making process rather than solely focusing on the parties involved. Thank you.
Laura, if I might chip in, but only briefly from the perspective of a humble practitioner, I'm not sure I share these concerns, certainly to the same extent as the other panelists. Treaty disputes, as you all know, are decided under the law that is specified in the treaty, which is then lex specialis, and they will only the investment tribunals would only consider these types of treaties to the extent they impinge on the dispute, and that's something that investment treaty tribunals are both used to doing and well qualified to do. And if we take a recent example, we're kind of talking about this like it would be like this crazy new thing, but actually it's something that treaty tribunals have been doing for years. So if you look at, for example, intra-EU disputes, there's now a whole bunch of tribunals that have had to consider, for example, and interpret the Treaty on the Functioning of the EU. Now, of course, the EU gets very upset about that and says, well, you can't do that. You don't have the power to interpret it. Well, but they can interpret it. They clearly are able to. What they don't do and can't do and couldn't do in any event because they don't create precedent is pronounce definitively on that treaty, but they can interpret it within the framework of the dispute and to the extent necessary for deciding the dispute that is before them. And I'd suggest that that's what investment tribunals would do here, and they would interpret, for example, the Outer Space Treaty only to the extent that they were required to determine that dispute. But I don't anticipate that any investor state tribunal would ever presume to pronounce definitively on the interpretation of, for example, the Outer Space Treaty. So I think I'm a little less concerned about it than some of the other panelists.
Thank you for clarifying this. I agree. I think the concern is more that, for example, on property rights, if we have the two views, maybe under national law, that there can be property rights in space, and under the Outer Space Treaty, arguably not, a tribunal would probably need to take a position. And if several tribunals take the same position, this kind of emerges as one opinion, whereas maybe arguably a tribunal is not the right actor to make this decision. But I completely agree, and tribunals have experience in dealing with these kind of